Hello and welcome back. In this recording, I want to talk about some of the concepts that are covered in Chapter 8 of your textbook. And as always, if any of you have any questions about anything that I bring up in this recording, or any of the material in your text, in the PowerPoints that I send to you, or any other material that you might get, contact me. Get a hold of me by email. Some of you have emailed me questions. I enjoy getting those. I enjoy responding to them. You can contact me by text message if it's something a little more urgent. Or, if absolutely necessary, give me a call. And if I don't think I can get your answer to you in an email or a text message, I'll tell you to give me a call. When you do send me a text message, please include your name, because I won't recognize you by phone number. Tell me who you are. All right. First of all, I want to talk about the concept of jurisdiction. Jurisdiction is important, very important to the court system, because the word jurisdiction means the power to do something about this particular problem. Police officers have jurisdiction. Police officers are limited to limited to the area in which they work. If they're a municipal police officer, they have jurisdiction only within that municipality. If they're a county deputy, they have jurisdiction only within the geographic limits of their county. If they're a state officer, they're limited to that state that they're in. There are some exceptions to all of those rules, the primary exception for police officers being the issue of hot pursuit. Police officers can chase suspects, and they don't have to stop chasing someone simply because they cross a geographical boundary line. They can continue that chase, but they're limited in making arrests. They can stop someone, they can hold that person when they catch them, even outside of their jurisdiction, but they can't actually make an arrest unless there's an officer from that jurisdiction present. So, police officers are limited by this concept of geographic jurisdiction. And likewise, courts are limited by the concept of geographic jurisdiction. In Illinois, every county has what is called a state's attorney. That prosecutor can only charge people within the county in which they're the state's attorney. And they can only charge them for crimes that occurred within that county. Now, it gets a little interesting because, as with everything in the law, there are exceptions. For example, I had a case many years ago as a state's attorney in which we found that a person who lived in an adjoining county was selling drugs that were being transported into Clinton County. In other words, Clinton County people would go to her, would bring the drugs back into Clinton County, and then would distribute them. They were, in effect, working for her. We charged her, even though we could never prove she was actually in Clinton County, but we charged her with a conspiracy to deliver drugs in Clinton County. But there still had to be a crime occurring in our county in order to bring a charge against her. That is the political boundary of a court's authority. So I, as a judge in the state of Illinois, could only hear cases from the state of Illinois. When I cross a boundary line, I'm not a judge in that state. I have no authority outside of my own state. In some states are even more compartmentalized than Illinois is. For example, in the state of Missouri, they have municipal courts, they have county courts, and they have state courts. So if you get a speeding ticket and as you're driving past St. Louis, you might have to appear in the municipal court of whatever small jurisdiction you happen to be in. And in that jurisdiction, the prosecutor will be a part-time prosecutor who usually has a law practice doing something else. The judge is frequently a part-time judge who has a law practice doing something else. And so the procedure is very different, and those courts are courts of limited jurisdiction. Then they have county courts. So for bigger offenses, for example, if you're arrested for a theft or a battery or something of that type in St. Louis County, you don't appear in a municipal court, you then appear in a county court. But if you're arrested in the city of St. Louis, you appear in a city court. So every state sets these courts up a little differently, but every court has a geographic jurisdiction, beyond which they have no authority, beyond which they have no power. They can only hear cases that arise in that jurisdiction. That's geographic jurisdiction, the political boundary of a court's authority. And likewise, when a defendant charged in that geographic jurisdiction goes to trial, it has to be held in a court in that area where the crime occurred. In Illinois, if you're arrested in Lebanon, you have to appear in St. Clair County, and your trial has to be held in St. Clair County. Again, as always, with a few exceptions. But the general rule is you appear in and you're tried in the county where the crime occurred. If you cross the county line into Clinton County, well, then you appear in court in Carlisle, in the county courthouse in Carlisle, and likewise across the state. If the crime occurs on federal property, you can be charged like a federal park. If you come to Carlisle Lake, which is a federal park, then the federal court will have jurisdiction, could have jurisdiction over that crime. For example, there's a federal law against minors consuming alcohol on federal property. So for a long time, federal park rangers would arrest minors at the lake in Carlisle, and they would then have to appear in court in the federal courthouse in East St. Louis. They could also, because they're still within Clinton County, they could also have been charged in state court. So both courts had jurisdiction when the crime occurred on federal land. When crime occurs on an Indian reservation, then the Indian court has jurisdiction over that crime, whether it's committed by an American Indian or by a person who happens to be visiting upon that native reservation. And likewise, if the crime's committed on a military base, it will be tried by a federal military court having jurisdiction. So geographic jurisdiction determines where and what courthouse the charges have to be brought and where the trial has to be held. Now, another type of jurisdiction has nothing to do with where the crime has occurred. It centers on the type of court that's hearing this case. This is called hierarchical jurisdiction, and it depends upon the type of court. Primarily, it refers to the difference between trial courts and appellate courts. But as I've already pointed out, some courts are in this hierarchical jurisdiction, have a very limited jurisdiction. In some states, they have traffic courts. They have municipal courts who can only hear minor traffic matters that happen within that jurisdiction. That's part of their hierarchical jurisdiction. Generally, though, in most states, we refer to the lowest level of courts as trial courts. Trial courts are the courts you think of. They're the courts you see on television. They're the courts that try facts. That's where jury trials are held. That's where trials before a court are held. That's where witnesses are called and there's a determination of guilt or, now the PowerPoint says guilt or innocence, but it's actually guilty or not guilty, meaning either the state has proven the defendant guilty beyond a reasonable doubt or they have not proven the defendant guilty beyond a reasonable doubt. In actual fact, courts never say the defendant is found innocent or found not guilty, meaning not proven guilty. Trial courts hear those trials. Appellate courts, on the other hand, have a different area on this hierarchical jurisdiction. They don't conduct trials. They only they review what happened in the trial court, and they can only rule on questions of law, not on fact. Appellate courts can only determine if the law was applied correctly. They cannot rule. The distinction between trial courts, the lower criminal courts, and the appeal courts are that appellate courts cannot decide a question of guilt or innocence. They just review what happened in the trial court to make sure that the trial court properly followed rules of procedure and that the trial court didn't violate the defendant's constitutional rights. Most defendants never appear when their case is being argued by the appellate court, because that's just formal argument by attorneys about the law that was applied. The trial court cannot review whether or not the defendant is actually guilty, and they cannot review the question of whether witnesses should be believed or not. That's the function only of the trial court, because those witnesses are testifying at the trial court, and the judge and the jury are in the best position to decide whether they believe that witness or don't believe that witness. And appellate courts cannot review that question of whether a witness was being truthful or not being truthful. That's a decision only for the trial court. Now, most states and federal judiciary have two levels of appellate court. The first usually we call them courts of appeal, but they're intermediate courts. They're the first layer of appellate courts. And appeal to these courts is almost always what we call an appeal as a matter of right. Anybody who's found guilty has a right to appeal to that first level of appellate court. And then most states have this second layer, usually called the Supreme Court. And the Supreme Court reviews the decisions made by the appellate court. The Supreme Court, not an appeal as a matter of right. The Supreme Court looks at thousands of requests for review, and then they only pick the cases that they want to hear. And for example, in the state of Illinois, they will frequently receive 3,000 or 4,000 requests for appeal every year, but they'll actually only hear a couple of hundred cases. When a case is appealed, remember the appellate court, the intermediate appellate court, can only review the objections made by the defense and the prosecution, including whether the defense attorney made the necessary objections, whether the defense attorney presented all of the evidence that they could have, and whether the defense attorney properly challenged the state's evidence. These appeal courts can review the rulings the trial court made on objections. Did the trial court make correct rulings or not? On pretrial objections and objections made during trial. Whether the government proved its case beyond a reasonable doubt. Is there sufficient evidence? And finally, was the sentence imposed upon the trial court appropriate or inappropriate? The Supreme Court, again, gets to pick what kind of cases that they want to hear, and they usually decide to hear cases where different appellate courts within the same state disagree about a particular issue. This is an area I wish I had all day to talk to you about. Obviously, I only got a couple of minutes. I'm going to have another recording on another issue covered in Chapter 8 a little later. And in that one, I think I'll be adding your assignment for this week. Thanks again for all the work you're doing. I'll talk to you again soon.